Are payable on death accounts safe? I'm going to answer that question for you in this video. Hi, I'm probate attorney Dan Scott, and I frequently have a scenario where someone comes to see me and we're doing a will for them and we begin talking about their financial accounts, and they say, well, that's okay, that's a payable on death account. We call them a POD account. It's a payable on death account. I've designated my daughter as the beneficiary on my death, so we don't have to deal with that in this will. And as a general principle, we don't even mention them in the will, right? I mean, I think that's standard practice. You don't mention them because the belief is there's a contract with the bank that says, father owns the account and daughter is the beneficiary on death. It's a payable on death. So on the death of father in this example, the belief is that that money immediately becomes owned by the person that is in the beneficiary under the payable on death account. Well, guess what? Guess what? We may not be safe in relying on that any longer, and here's why. The Tennessee Court of Appeals just issued an opinion just a few days ago in the case called Cunningham Executor against Eastman Credit Union, in which they considered whether that account would go to the beneficiary on the payable on death account or would actually go in accordance with a handwritten will that the testator had written after the account was set up. Now, to me, that turns things completely up on end, because I think that most people, most lawyers, and most individuals that are non-lawyers believe that if they have a contract with the bank that says that the money is payable on death to daughter, then that's what's going to happen. Before I read this opinion, I thought there was never any doubt about it, right? That you really didn't have to have that conversation. But I can tell you, after this opinion, we've got to have the conversation. Let me kind of walk you through the facts. Sometimes we say in the law that bad facts make bad law, right? Now, I don't know if this is a case of bad facts make bad law, but here's what happened. Ivan Zanthrall had 4 bank accounts. 3 of them at Eastman Credit Union and the other one at Franklin Bank. And the accounts were payable on death accounts. That is, Iva had designated Marion Dodd as the beneficiary, the payable on death holder, that is the person that would receive them upon her death. And so in 2013, Iva does a will, and she did the will at her cousin's, who's a lawyer, at his office. And, she didn't leave anything to Marion Dodd. Did nothing, left nothing. Commonly, if you've already, and I'm talking about what happens in practice, if you've already got a contract that says Marion Dodd is going to get this money by virtue of the contract I have with the bank, there's no need to put anything in your will that would say Marion Dodd gets that account, right? Because you've already got a contract that says that. And so that's what happened. The will doesn't say anything about Marion Dodd. It appoints Marion Dodd as the personal representative, but it doesn't say anything about Marion Dodd getting the money in the bank. Why? Because of their contract already. It's called a payable on death account. That's the reason I ask you, are those safe? Before I read this opinion, I said, well, this is not even a question. Well, they go to trial on it because here's what happens. The executor of Iva's estate files a lawsuit. Let me go over with you what happened. After the 2013 will is written, in which Marion Dodd is not mentioned, right? Remember, the payable on death accounts are already established. There is a handwritten, what they call holographic codicil. And holographic just means written by hand. And generally you can do a holographic will. Lawyers don't recommend that you do it. The will must be completely in your hand, okay? And you can do a holographic codicil. Lawyers don't recommend it, but you can do it. Iva passes, and so now an estate is opened, And the executor of that estate, Marion Dodd, who was appointed in the will, the 2013 will, does not serve as executor. And Jerry Cunningham gets appointed as executor of this estate. He files an action, a lawsuit, and he alleges that the payable on death designation is not relevant, that those accounts do not belong to Marion Dodd, that those accounts belong to this estate, and they should be distributed in accordance with the will. And he argues constructive trust and some other equitable theories, right? But what he does not argue is that Iva had a contract with the bank to which Marion Dodd was a beneficiary, right? Where Iva said, on my death, this money should be paid to Marion Dodd. He doesn't make that argument. In fact, he even stipulated that the contract with the bank said that Marion Dodd was to get this money. So what happens? They go to trial, right? At the trial, the trial court holds that the money should be distributed in accordance with the will. Now stop right there. Stop. Because what we have now is we've got a payable on death account, really 4 of them, payable on death account, and now we're fixing to upset that because of this handwritten codicil. Now the handwritten codicil said the money I've got at Eastman Credit Union should go to Mr. Bailey, and the money I've got at Franklin should go to a Christian resort that I support, okay? Well, guess what? Until I read this opinion, I would have thought, well, that really is completely irrelevant because the contract says that that money is paid to Marion Dodd. Well, that's not what the trial court said. The trial court said, nope, we're not going to do it that way. We're going to treat that holographic will as devising money that the testator no longer had the moment she died. That's what I think, okay? Okay, and so the Marion Dodd goes up to the Court of Appeals and says, wait a minute. There's a contract here that says that money was to be payable to me on death. Reverse the trial court and tell the trial court I get that money. You know, I thought that was a pretty easy case. When I'm reading through the facts, I think, well, that's an easy case. But you know what the Court of Appeals did? Well, let me tell you what they didn't do. They didn't say, well, of course it is. Of course, you've got this contract, and you're the beneficiary of it. It's a contract between Iva and the bank, and you're a beneficiary of that contract. It says that you're entitled to this money the moment after her death. Didn't say that. What the Court of Appeals did is they said, look, the trial court hasn't made specific findings of fact, so we want to send this back down to the trial court and let the trial court make specific findings of fact. And then if somebody wants to appeal it, they can appeal it. Now, the Court of Appeals was completely within their rights to do that. They're entitled to do that. But here's the shocker. What they didn't say is this contract with the bank is an enforceable contract. They didn't say that. And I believe that upsets the law on payable death contracts. So if you're a lawyer watching this today, one of the things I would recommend that you do, and it's going to be what I do, I've got about 3 or 4 wills right now I'm working on. At least 2 of them have payable death accounts. Before this case, I would not have mentioned them in the will. So if you're a lawyer watching this, maybe you should consider doing what I'm going to do, which is I'm going to say, I've got an account at ABC Bank, and it is a payable on death account, and I direct the bank to pay on death to Sally, to my daughter, okay? Because that's the intention. I think that's the intention. Now, if the payable on death accounts no longer are enforceable, then we'll have to create some new law. And I think if you're wanting that to work for you based on this case, you better put that stuff in your will, because somewhere down the road it can be changed. I hope this is helpful. I did really want to shoot a long video. I know this one's long, but this really upsets the apple cart as far as payable on death accounts. And I'll tell you, a lot of my clients use those accounts because they don't want the money to be tied up. They want the money immediately to be available to a daughter, a sister, an aunt, right? But now the banks are going to be fearful. They're going to say, well, wait a minute. If I pay that money down to the daughter, the sister, the aunt, in my example, is the executor going to come back and sue me and say, you weren't entitled to do that? You know that those payable on death accounts are not enforceable? And I'll tell you, before this opinion right here, I believe they were enforceable, and I think most lawyers in Tennessee would have thought so too. Hope this is helpful to you. Be sure and come back and watch additional videos. We post them all the time for you. Talk soon.